Okay. Hi, everyone. Can you hear me in the back? Great. My voice doesn't always carry, so just raise your hand if you can't hear me. I'm Pham. I'm an attorney in downtown Seattle, at a firm called Helsell, Fetterman. We do all kinds of law, basically an all-service business firm. So business contracts, starting your business, employment issues. I do intellectual property and litigation there. We have family law, estate planning, you name it, we probably have it. So I'm here today to talk about legal issues in the gaming industry. And I can't promise that'll be interesting or, that kind of thing, but hopefully you'll get some things out of it that will be very practical and useful to you. So this is me, back when I had banks. I represent clients in the arts, tech, entertainment. I have clients who are children's book publishers, podcast hosts, gaming-related companies, etc. I advise clients from when they start their business or have an idea, all the way to protecting their rights in litigation and in court. So I do the full gamut. I'm a lawyer. There's always going to be a legal disclaimer. So, this presentation is not legal advice. I'm just telling you about the law. So this does not create an attorney-client relationship. But if you want to pay me or we have a real consult, then that would be an attorney-client relationship. All right. So goals and agenda for today. I want to give you an overview of intellectual property law, mainly as it applies to the gaming industry. So we'll be covering topics like patents and trade secrets. We'll be talking about trademarks. We'll be talking about copyright. And we'll also be talking about a few other areas of intellectual property that you may not be aware of. Then we'll move into common contracts in the industry and protecting your confidentiality as you are while you're developing your idea. Finally, I'll have some basic tips for navigating the industry once you graduate and you join the force. And finally, we'll have some Q&A. So what is intellectual property? It's all around us. It's intangible. There's analogies to like real property. When you buy a house, for example, you can sell it, you can rent it. In intellectual property context, you'll be licensing it. And if you don't protect your borders, you can lose your rights to it. So it's a very valuable right and type of property that you hold and that you create that is really valuable and that you can make money off of, right? So I have this really dense slide of intellectual property, and I'm not going to go into detail, kind of already covered it. But what is the importance of intellectual property? It's the law is there to help you protect the things that you create and to foster that, and to give you basically a limited monopoly on that for a while. And moving on. So here's an example of intellectual property in practice. So when you look at the Nike Flyknit shoe, there's a number of types of intellectual property that applies to it. So you have the check mark, which is a trademark. It's something that designates the source. When you see that check mark, you know it's the Nike shoe, right? We have a patent, a design patent, in the way that the fabric is knitted. And we have copyright. Sorry, I'm going to go to trademark, trade secret. We have trade secrets, which is your own secret underlying, let's say, the technology behind the knit fabric itself. And then finally, we have copyright, which is the way that the shoe looks, the colors on the shoe, for example. But copyright is interesting because there's multiple layers to this. So not only are we looking at the product itself, the shoe, and how it looks as copyright, but who is the person that took the photograph? They have their own copyright ownership in the photograph. So here's a little cheat sheet. Patents are for inventions and ideas. Trademarks are for brands. Copyright for your expression of your idea, as in, like your story, your art, your lines of code. And finally, trade secret is what you want to keep secret. For example, let's say you create an idea, but you don't want to make it public yet, and you're pitching it to different developers. That's a trade secret. So examples of that would be the Coca-Cola formula, the KFC recipe, customer lists. So I'm going to go through patents and trade secrets really quickly because it doesn't have a lot of application to you at this stage, but it can be important to you in the long run. So, like I said, patents are protection for your inventions, and they're unique because they can protect ideas, things that aren't even put to paper, put onto your computer or on software. And it's supported by our federal Constitution. In the Constitution itself, it says Congress gives our government the power to protect our creative works and our inventions, because the whole purpose is to promote the arts and to promote innovation. And there's different types of patents. There's plant patents. I bet you didn't know that, well, you may know, that you can get patents on cannabis. There's plant patents. But what we hear about the most are utility patents. Those are for new, non-obvious inventions that are useful to us in the world. Those could be things like new devices, new hardware, new software, etc. New gaming controllers, for example. And they're protected for 20 years at a time. So it's something that is made public to the world when you register it with the government. But you get a monopoly on that for 20 years, and nobody can reverse engineer it, nobody can use it. Here's some examples of what patents would look like when they're filed with the USPTO, which is the US Patent and Trademark Office. On the left is it's a component for a Tesla car. On the right is a nuclear reactor. There's also such things as design patents, and this is probably where it's most useful to you, because design patents cover designs, ornamental designs that have no function or use. So for example, the design of an end product, like the design of a controller itself, right? Design aspects of certain websites, gaming sites, screens. The best example of this is the Coca-Cola bottle, the glass bottle. Like when you see that glass bottle, do you automatically think of Coke? Yeah, exactly. And those are protected for 15 years at a time. So let's say you go through the process of registering for a patent, and you have the exclusive right to sell this product or license it out for 15 or 20 years. But then somebody starts making that product and copies it. What are your rights? It's mainly through patent infringement claims. And so it's defined under the law, under a federal statute, and it's basically you can prevent people from making, using, offering to sell, or sell any aspect of your invention. And it prevents others from importing it into the US. And you can use it across the world. It's really expensive to do that though. We're seeing a decline in it because it's like over $1 million just to get it to fruition. Like startups, it's hard for startups to compete against the big Goliaths. Trade secrets. So like I said before, trade secrets often come in when you have the idea, you're still developing it, and you're pitching it. It's a secret that you're keeping, that it's just valuable information to you to give you a competitive edge. So examples of that are your customer lists, your brief clip of your animation, of your game, etc. So, when, and let's see, trade secrets are protected by state law. It's not federally run, so it's different in every state. So in Washington, we have this law called the Uniform Trade Secrets Act, which is actually really common across the nation, but each state gives you different rights. So this is where having an attorney come in is really important. But it can last forever, as long as you keep it secret. So, under the law, not only do you keep it a secret, but you have to take reasonable steps to do so. So, putting the confidential designation on your work, saying do not disclose, bringing in an NDA. How many of you have heard of NDAs or dealt with them? Pretty much everyone. Okay, good. Okay, I'll be covering that later as well. Patents are not trade secrets. And the main reason is that patents are not secret. They're disclosed to the public. So, with trade secrets, the best ways to protect that are through contracts, through those NDAs, through employment agreements, through non-competes. If at any point you walk into a meeting and you don't have even a handshake deal or a written agreement, and you start telling your idea, it's no longer a secret. So it's really important that you have it in writing and you can show that to somebody. Trademark. Here are some trademarks that you might recognize. Microsoft, Coca-Cola, McDonald's, KFC, Apple, Nike. But what is it? Trademark can be a word, a symbol. It could be, it's a word or symbol that designates a source, like the company behind the product, behind the service. So when I look at a trademark, it's meant to remind me of the company that's creating it. And the reason why trademarks are so amazing and have so much value is because it shows the quality of the product. So when I go and grab a Coca-Cola bottle from the fridge and I see it in that telltale like red and white Coca-Cola font, I'm going to expect that it's going to taste like a legit Coke, right? So that's what it's there for. And it can come in a number of forms. It can be just words or a phrase or slogan. It could be a symbol where it's just a picture. But it can also be a combination of that in what's called a composite mark. It's words and design. So here's some example of word marks. Microsoft, EA, but also Electronic Arts, EA Sports. You can also have a slogan like greatness awaits or just do it. Composite mark. That's where it's a combination of the picture and the words. So here's Steam's example of a composite mark, Nintendo Switch's example. Or it could just be, well, imagine the EA wasn't there, but it could also be a symbol where it's just the check mark of Nike. It could just be the apple. Oh, that might be hard for the people in the back to see. So you can, when you're developing your trademark and you're kind of coming up with a cool, badass name for your company or for just for you, there's some things that you should consider when you're developing your trademark. You don't want it to be, I guess the whole point is for it to be really distinctive for the type of goods or services that you're providing. So if you're a game designer, you don't want to name it Michelle's Game Designs. That's too descriptive. You want to come up with something like Apple did for computers. You don't think of apples with computers. But, if I just made up a I'm still not good at making up random names. If I used Nintendo for law, arguably, that's distinctive enough because Nintendo doesn't operate in the legal field. So there's different levels of trademark distinctiveness, where it's just generic or all the way up to, well, generic, descriptive, suggestive, arbitrary, and suggestive. Oh, sorry, I think I mixed it up. Generic, descriptive, suggestive, arbitrary, and fanciful. So suggestive would be like Android for phones. Arbitrary would be Apple for computers. But fanciful is just a made up name. Exxon for oil, for example. Why do they matter? They differentiate your product from anybody else's. You get exclusive rights to your trademark. You get a litigation advantage when you register your trademark. And you get potential worldwide protection. It ranges from state level to federal level, all the way across the world. And it's something for you to buy and sell and to license out. Some very basic principles for trademark. First to use it has priority. First in time, first in right. So let's say you start using Nintendo for legal services. This is a terrible example. Nintendo for legal services. I used it first, and I have evidence that I used it back in 2010. And then somebody comes along and they post a website that's also called Nintendo Law, but they started it in 2016, and they can't show that they used it before me. So even if they go to the USPTO, they go to our state, and they register that after me, I can still go in and say, sorry, sign it over to me, or cancel it because I used it first. So documenting it is a really good idea. And using it with your product, with your service is good. Another idea with trademark that's very different from patents and copyrights is that you have to use it with your product or service. You have to use it or you'll abandon it. So once you register it, or once you register it and you stop using it and you don't file declarations with the USPTO saying that you're still using it after 5 or 10 years, they'll cancel it, and so somebody else can use it with those products. So you want to stay on top of that. How do you obtain trademark rights? One, you got to use it, like I said. If you just use it and you don't register it, like you don't pay the fee and you don't get like that certificate from the USPTO or a state's Secretary of State, you still have rights. You can still prevent others from using it in your state or in the states that you had already started using it. But it's not the best protection that you can get. And I say that because once you register it, you get all these additional protections under the law, like I said, the litigation advantage, right? You are presumed to be the person who was first to use it, the person who has not abandoned it, etc. And you can go and you can tell websites to take down infringing works through the takedown process. You can prevent products from coming into the U.S. or products being sold on Amazon or eBay, etc. From copies being made. So ways that you can protect it. You can go to court, which is always expensive. I don't advise it, but I do. It's meant to protect your work from others that could be confusingly similar. That, somebody takes your work or a similar version of it, and it just seems, and they say, they kind of present it as though it came from you, right? That's trademark infringement. And you can collect damages on that. If they made money off of it, you get all that money back. Registering it with the U.S. Trademark Office. They won't issue it if it's too confusingly similar to somebody else, so do your initial research. So I often tell clients, if you're thinking about developing a trademark and you're not sure whether others are using it in the nation, do a Google search, do an image search, see if it's being used, and if it's being used with the types of products and services that you are going to use it for. That's a good initial check. Like I said, it's always best to just come up with a random name, right? You can also use the Trademark Office's database of trademarks to say that somebody's applying for a trademark that is infringing upon my own, right? It's a way for you to research but also get notice of others trying to use your trademark. And like I said, you can cancel somebody else's. Standard likelihood of confusion, kind of already covered this, but it's the similarity in the trademark itself, where they just straight up copy your logo, or they copy your goods. There's other things too that are considered, but you don't have to have actual confusion. You don't have to go out there and do thousands of surveys to make sure that people are confused or not. You just have to show that it's likely to confuse consumers in the marketplace. Okay, here's the real stuff, copyright. So what is copyright? I think we all have a general idea of what copyright is. It's protection of our works that we put into some tangible means of expression. So, doodling on paper, doodling on your iPad, drafting lines of code in the background, creating your animations on software, that kind of thing. Not something that's in your mind that hasn't been manifested out yet. As soon as you put it into some form of expression, tangible form of expression, it's automatically protected. So you don't have to register with the Copyright Office. You don't have to do all those things. As soon as you put it down on paper, etc., you get that protection. Copyright only protects 8 categories of creations, and they're listed here. I'll just run through them really quickly, which is dramatic works, literary works, sound recordings, musical works, architectural works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, and audiovisual works. So examples would be music, code, stories, characters, art, box designs, website designs, a lot of things. But you can't get copyright protection for things that are functional, things that have to be incorporated into something for it to be used. So in games, there's always going to be a scoring system. Or like maybe coins for a certain type of game. There's always going to be some sky or ground in certain games, for example. Those are things that always need to be there, and those can't be protected, like those aspects within the game, right? To put that into context, when you think about a golfing game, you're always going to need holes. You're always going to need golf balls. You're always going to need clubs, golfers, grass, etc. But what you can get protection on is how they look, right? So that character can exist in, could look like any number of people that you create. You can have different colored golf balls. You can have different shades of golf clubs, for example. Maybe you come up with some new design for a golf club that's presented in your game. Those are protected. So, like I said, you automatically get protection, but you get better protection when you register and when you mark it as copyright protected. So as soon as you create that work, ideally you would put that C with the circle around it in the corner or next to it with your name and when it was created. and when it was created is important because copyright protection only lasts for a limited number of years. Typically, it's the life of the creator plus 70 years. So you can actually pass on your copyright rights to your kids, to your family, to your estate. And then registering it is another form of protecting it. And it's really low cost. It's $35 to $55 per item, but you can also get it protected in a series. So for example, if I registered like a comic strip of like one strip, right? But it's indicative of a bigger series. So I did one strip of Marvel's Avengers. Let's say I created it. Obviously I didn't. I wish I did. If I took the Avengers and I did one strip and I registered it, I can register it as a series, and that protects all of my later ones. So my entire work of art for Marvel Avengers could be protected within that one $35 to $55 registration. So it can be a really cheap and good way of protecting your work. But you get other benefits out of registering that. You get a presumption that you are the owner and that your copyright is valid for as long as you register in the first 5 years of creation. That gets you access to statutory damages that run like $25,000, $50,000 for every time that it's infringed. So let's say I took your work and I sold 100 copies of that. Multiply that by the thousands that you can get from statutory damages. It's amazing how much benefit you get from just registering it for $35, $55. So I think I kind of already covered why copyright is important. You get the right to reproduce your work. You can either publicly perform or display it. You can distribute it for sale or for lease. You can create derivative works from it. And an example of that is my comic strip for Marvel Avengers. I'm turning into a movie. So that's a derivative work. And I can also authorize other people to have some or all of these rights. And you can make money off of it. You can license it, get royalties, etc. So to recap on ways to protect it, mark your work. Here's an example. Just say copyright with the C circle, year, and then your name or your company's name. Register the work. Keep or register supporting evidence about when you created it, but also when people might have infringed upon it. Be on top of licensing deals. Get it in writing. If you're creating it with somebody else, who owns what? Are you owning it together without any description as to what? Are you just, do you own half? What do you own half of, right? And then, do you want to assign it? Do you want to give it to your employer, for example? Or do you want to keep it for yourself? How do you deal with that? You can send out cease and desist letters with any type of IP, and you can go to court. So with copyright infringement litigation, I'm not going to read all of this, but basically you can go to court for it, and basically you can prevent others from exercising any of those main rights that I talked about earlier. Fair use. So people talk about fair use a lot, and there's often a misconception about what it is. When I'm in a conversation, somebody's like, oh, no problem, I'm not going to get sued, it's just fair use. Actually, fair use is a defense, so you have to go through the entire process of going to court and going through litigation and defending yourself, and the other side has to prove that they have a valid copyright and that they own it first, and then you claim fair use. So it's still an expensive endeavor, and it's it's tough because you have to go through this entire process to just claim fair use. So, and it's not easy to show. It's a multi-factor test. It's mainly up to the discretion of judges who may not understand what you're doing or what your work is. So, it's not easy. And oftentimes, and this is why you don't see a lot of copyright cases, oftentimes these cases just settle because of that. So, I have 2 examples of cases in here. Let me do a time check. Okay, yeah, I don't have that much time. Let's skip them. Okay, other types of IP, rights of publicity. Does anyone know what rights of publicity are? Nobody. Okay. So I explain it as your celebrity rights. Any one of us could be celebrities, and I believe you all. But it's a state protection. It's a state right. Not all states have it, but Washington does. So a good example of this, rights of publicity is the right of an individual, you, to control the commercial use of your likeness, your name, your image, things that are so very you. So an example of this is Obama's picture in Shepard Fairey's Hope poster, right? If Shepard Fairey had not gone to Obama and gotten some right to use his image, Obama actually would have a good argument in Washington, in California, New York, and some other states to say, for however much money that you got from your poster using my image, I think I get money out of it. So when you're taking pictures or you're using pictures of celebrities or likenesses of celebrities in your games, this is something that you should think about, especially in states like Washington. And another example of likeness is Vanna White. She sued Samsung because they created a robot in an ad that went across a Wheel of Fortune stage and turned letters. It wasn't even her face. It was just her as distinctively Vanna White. Like, everybody knows that she's the Wheel of Fortune letter turner, right? Just having a robot that acted like her with the Wheel of Fortune contacts was enough for her to get money out of Samsung. Other issues, internet and privacy law, putting things up on websites. Those are some things you should be concerned about. People can take that, use that. First Amendment rights and censorship. So oftentimes in our gaming world, we push the boundaries as to like what is offensive at times, right? I mean, and so for example, like there was all that talk about Grand Theft Auto and how it's so bad for kids and that kind of thing. So there's a case that came out of California and went all the way up to the Supreme Court of the United States about things like that. And the Supreme Court said, First Amendment rights rule, states cannot censor our ability to create video games that have this type of content. We have our freedom of speech, and that applies to video games as well. Common contracts and confidentiality. I'm not going over all of the potential contracts out there, but I'm just highlighting some of the main ones that you'll probably interact with in the near future. And I think the biggest one is employee versus independent contractor contracts. Some of you will be hired and straight into companies as employees. Everything that you make for an employer is the company's. It's not yours anymore. But if you're freelancers and you operate outside of the employment context, you actually own all of your intellectual property as a default. So if you don't have some written agreement and you're just hired on and you're paid hourly, whatever it is, and you create all this stuff for like Microsoft Game Studios, right? You actually own that. You can take it with you. A lot of people don't know that, and I have gaming friends, game designer friends, who did not know that when they first entered the marketplace. And so they could go back and ask for it. or get a license permit. I'll take questions at the end. Okay. But on the company side, dealing with independent contractors, what I always advise companies is get it in writing that it's a work for hire. It needs the magic language in there for them to take ownership of your intellectual property and what you create. So I would keep an eye out for work for hire, work things where it says like specially commissioned in the contract. Those are some magic words for work made for hire. Licenses. There's a number of different types of licenses, and you can get licenses for all of the intellectual property rights I told you about. You can split it into patents. You can split it into just copyright, or just trademark, or all of them. You can split copyright into the individual rights that I was talking about, buying, selling, distributing, or creating duplicates, etc. As you can imagine, that's probably one of the best ways for you to make money off of your work, right? You can sell limited rights to use your work, or just exclusive, whatever it is. You can tailor it as you want. And you can set crazy things, like Paramount Pictures owns the Star Trek franchise, and they have this constant clause that says any game that shows the USS Enterprise can't show it being destroyed. NDAs. I didn't go into like the main clauses of the NDAs. That's something that, if you ever have questions, you can feel free to reach out to me or any of these topics. But have them, take them with you, get it in writing. Don't just deal with handshakes. I know in the industry, there's a lot of handshake deals. It happens in a lot of other industries, but when you know it's really important to you, it's something that could be lost. A one-sheeter NDA saying that they're going to keep whatever it is secret and not distributed will save you. And you can have it unilaterally or mutually. Unilaterally is, mainly just people who are outside of the industry, where you're telling them don't tell the public. But then you can also have it mutually, like let's say you're meeting with developers and you're both going to use the information for further discussion. That could be mutual. Development contracts, those are contracts between publishers and developers. It outlines a whole bunch of things: royalties, financial terms, what's actually being licensed and used, marketing plans, distribution plans, all of that. Oftentimes, a lot of information is appended to the end, and that's the easy way of handling it. End-user license agreements. If you're posting it onto websites, you want to have these end-user license agreements that people click through. In terms of use. Tips for navigating the industry. Okay, these are very basic. I can give you a number of tips and I can be here forever. But do your homework, do your research in terms of what people are using and whether you might be copying somebody else. Chat with a lawyer. And when you see others, this is just a practical thing. If you see others misusing or copying your work, consider, is it just an innocent mistake, or are they actively copying? Not all copying is vindictive or like has some negative intent, right? And which brings me to my final point, which is there's so many things. As a lawyer, I look into every detail. I want everything written out and addressed on paper so that I know how to deal with it later on. If I'm new to the entire deal and the situation, I could just look at the contract and know exactly how to deal with it. That would be the ideal contract. We often don't have the strength, like the position of strength to negotiate. We often don't have the terms, like the money that we want to get out of it, etc. And those are the kinds of like business-related decisions and considerations that go into contract negotiations that I couldn't tell you about, and it's really a case-by-case basis. But when you're approaching these contracts, you want to think about what are the main things that you really care about that you cannot give up, like maybe your IP ownership, versus what are you willing to be flexible on, the amount of royalties, that kind of thing. So this is, contracts in the law is very fluid, and oftentimes, you can't always put it into writing and into a contract, and that's something to consider as well. Questions? I think we have 14 minutes. Okay.
That's pretty good. All that long. You spent 4 or 5 years studying. You just packed it into 45 minutes.
That was a lot. I'm sorry for overwhelming you, but I'll take questions. I'll start over here.
So I have 2 quick questions. First off, this might be a dumb question, but where does the money go? Like, obviously there's a lot of money and people paying for copyrights and things like that, but where does it go? Does it just go to the government and get kind of spread around, or what does it fund?
Do you mean like when you register?
Yeah, like when you're registering things like that.
Okay,
People
so
pay for it.
yeah, so the question is, where does the money go when, let's say, you're registering, applying for copyright or applying for a trademark, right? It's purely administrative fees. There's attorneys on the other side who review your application, especially in trademark, and they're doing the research in the background in their database to see if your mark in connection with the goods and services that you're applying for aren't confusingly similar to other things that are already out there and being used. Yes.
So you said that functionality could be intellectual property. And I was wondering, what if there's certain functionality in your game that had no real-world counterpart and was truly unique to your game? Would you be able to have that as intellectual property or not?
I think I would need a little bit more information. So can you give me an example?
I can't think of a good example right now, but I can only give an example of when it didn't count as their intellectual property when PUBG was upset that people used parachutes in their games. Not like that, that's something that didn't have a real world counterpart.
Yeah, so let's say you're creating a new world, for example, in your game. And
specifically functionality, like it's a functional thing in your game, like maybe a way of generating a world or something like that.
So the question is, to what extent is the functionality behind the game protected by intellectual property?
Yes.
I'm rephrasing it. And it really depends. So I'm just gonna rephrase your hypothetical to say, let's say you came up with some new line of code or new functionality that's entirely new in this world and no one else has ever thought about it. You might have some patent-related intellectual property, You might actually have some copyright too for lines of code behind it. So it really depends. Yeah. Yes, for that. Yeah, so the question is, does it help if I mail myself my invention and kind of preserve the date stamp on it? Well, I mean, it wouldn't hurt, but it's kind of an old school way of dealing with it, just because that was back when we could only have paper mailings and we couldn't submit it online. So, and we have timestamps on all of our computer-related software and work now. So, we can look at the metadata and we can do that to get it instead of just mailing it to ourselves, but why not, right? Yeah. Yes.
How do you combat theft overseas?
How do I combat stuff overseas?
Theft overseas.
Oh, theft overseas. It depends on what you're protecting, patent, trademark, or copyright. And if it's digital or if it's an actual product, like tangible product.
Yeah. Mainly like digital. Like somebody
Digital?
I feel like it's kind of a common occurrence for like China to like steal your game and basically just rip it and reskin it and sell it for themselves.
Yeah. Yeah.
How do you deal with it?
There's no easy way to deal with it. A lot of it is treaties, and it's whether they'll honor it or not. There's a lot of like bureaucracy and political pressure, maybe. But let's say they still subscribe to, let's say, takedown practices. So, for example, just yesterday, we found a Chinese website that posted and they have a sales page for a barbecue grill that our clients created. And it's sold in China, it's sold across the world. And this particular website has a special IP takedown procedure and platform. And we register ourselves as the agent of the company, and we just file a complaint. And we're like, here's our certificate where we own the patent on the grill, and we also own the trademark on the grill, and the name of it. Take it down. And that's one of the initial ways that you can deal with it. There's litigation's not worth it. It's really expensive unless you're with a big company. That's a short answer. Yes. In the back? I'm sorry, I'm gonna come closer because I can't hear you. Yeah, so the question is, I'm printing business cards and I want to put, let's say, a Facebook logo or Twitter, LinkedIn logo, for example, and is that infringement? I would argue that it's fair use. You're not presenting those trademarks as though you are selling or as you are them, basically. So you're using it for a different purpose, and you're likely not going to you're not going to be confusingly similar. That's the standard. So I think you'll be okay. Yeah. Not legal advice though. Yeah. Sorry, I saw his hand longer.
Maybe a little specific, but what if I wanted to make a new video game or a video game company, and I wanted to name it after an actual real place, established place? Like, let's say I wanted to name it Mercer Island or the Grand Canyon. Is that something that can be trademarked? Do those cities already have a trademark for that kind of thing?
There have been some. Oh, so the question is, I have a game and I want to use a city name in it. Can those be registered, trademark protected? Actually, Kentucky has trademark protection in Kentucky. That's why Kentucky Fried Chicken changed their name to KFC. I thought it was because they didn't have chicken, but no, it's because Kentucky has a trademark in Kentucky. So it depends on what city, what state, etc. You just have to do
If
research.
they don't have it, right? Like, let's say I wanted to
Yes.
make the Grand Canyon Games,
Yeah, but they've been using the name Grand Canyon with the park
Yeah.
way longer than you have. And it's first in use, first in right?
Okay.
So they can come back and tell you to stop. And you don't want to waste all that goodwill and all that time and money. Questions over here?
So if I had like an idea for like a game that I wanted to potentially like make money on, is there a time where it's like too early to like trademark your intellectual property, or like do you just want to give them and sell it afterwards?
So your question is, let's say you already created a game and you kind of just want to get it out there, you want to start making money on it and start marketing it without going through the process of trademark or registering for copyright, right? Or
Like if you had like an idea for a game that wasn't fully like marketable yet,
okay.
is there a time where it's too early to like trademark it? Like maybe if you don't like fully follow through with it, or like would you want to like trademark that as soon as you can just to like protect yourself? So that's the idea.
Yeah. So the question is, I have an idea and it's not fully formed yet. I haven't fully created a game. When is it too early to seek registration of a trademark or copyright? Copyright you can when it's not created on paper or on software or whatever. It has to be fixed in a tangible form, like I said. Trademark, and I didn't talk about this, but there's two types of applications. One is where it's already in use and you're ready to move ahead to get the registration in connection with your goods and services. So if in the instance, let's say you had the idea and you're already starting to pitch it to developers or whatever, and you have, like, let's say a company name in place and you're using that, you actually are already using your trademark even though you haven't created your work. So that's in use. But then there's also a type that's called intent to use, which means you plan on using it in the next 3 to 6 months, and you can extend that for a fee every 6 months up to 3 years. So that is another way to kind of preserve that company name or the logo and trademark in the trademark context. So it's a multifaceted answer to your question. Yes, sir.
What happens if I sign like 2 commercial CDs? I know I signed one for the school, I signed one for the next school, that's the main thing. Does any joint that's a thing,
Okay, so your question is, what if I have 2 conflicting NDAs? So I'm guessing you work for a company, but you're... Yeah, okay, so let's say you're working for a company already, whatever work you do belongs to the company, right? But you kind of go off on your own and you want to do something for a school. And does the company own that work? So this comes up really often. For example, like Microsoft employees creating works, right? They have to go through and clear with their employer before they go out and create those things on the side. Unless you can show so clearly that whatever you're creating on the side is so not within the realm of the company. So, the easiest way is to clear it with your company first. And then go do the volunteer work or do the other work. Yeah. Okay. And that? Okay, so the question is, you're publishing a book. You created and, let's say, illustrated and wrote the story for the book, and you're going through an online publishing company to kind of like distribute and be a platform for you, right? Who owns what rights? So this is where, when I said with copyright, you get all of these different bundle of rights. You can split it off. So let's say to be able to use that platform, they say, we get the exclusive right to publish your work and you can't go to anybody else to do it. That's one of the many bundle of rights that you can give to them. But you still have the right to make copies of it. You still have the right to make derivative works of it and all of these other things. Does that help answer your question? Yes, sir.
How do you know when it's worth it to go after someone for, like, say, IP theft or anything similar to that?
The question is, how do you know when it's worth going after somebody?
Yeah.
Really, it's a budget.
But
Yeah. And there's different ways of approaching it. So what I love and enjoy about my work is sitting down with a client and seeing, like, what's your priority here and how much money are you willing to throw at it? Because you can do things like just send a cease and desist letter and try to negotiate it out for a lower cost. Or if you have the unlimited funds, you can just go ahead and sue. So it's really a business decision. Yeah. Yes.
So kind of going on. So there's all these laws that protect you from things like that, but also especially in the sense of like what if it sounds to me more like you have to like I don't feel like don't have
So the question is, what if you don't have money and you can't go?
like China like copying and stuff now that other than setting the don't use it, I think if they still use it, they're not changing it.
Yeah. Yeah. So, like, in the same question. So it can be really frustrating when you don't have the funds to go after people, but on the flip side, if you don't have those protections and you don't get that registration, then it's harder for you to do so, especially with like everybody else, you know, the people in this community that heard about your great work and they're using it. People in the US and have access to it online in the US, you still have all of these other great rights, and there are just going to be those outliers in other countries or whatever. But you want to do your best to protect it in the cheaper ways, right? In the registration ways, for example, keeping good records as to when you created it, etc. So, to me, the alternative of not doing all that stuff will make your life way harder. You know, if
One last question.
yes.
Is there an open database for checking on IP and trademark and copyright and all that? Like, how do you know? Short of like a Google search can only do so much. How do you know that nobody else has like rights to a certain one?
So the question is there one source or database, or how can you do a more exhaustive search of intellectual property rights? There really isn't an easy way. That's why there are companies that are formed just to do searches like this and do comprehensive ones. It's just the extent and level of your cyber sleuthing or records. You can't always know, because there's going to be some dude in like Iowa maybe creating their own thing, and they're not online, right? So you can't get to that. But you can do some reasonable due diligence, like the Google search, like the government databases, and a couple other places too, which we can talk about later. To just do the best that you can. Like you just can't get it all in one swoop.
Well, we should thank Michelle for giving us the